Welcome, everyone, to the SLW Institute and the next in our Global Review series. My name is Maureen Kinsler. I'm the Executive Director of SLW, and I'm delighted to introduce my colleague, Matt Norwood, who is our speaker today. Matt is a US and Canadian attorney and has very considerable experience of litigating IP disputes in the Canadian courts and prosecuting patent applications before the Canadian IPO. And I'm delighted he's here to share his great experience in Canada with all of us. Matt is very happy to take questions as he's going through the presentation, and so please do feel free to put questions in the Q&A section. I'll keep an eye out for them and let Matt know when the questions come through. So many thanks again for joining us, and I will hand you over to Matt. Thank you, Matt.
Thank you, Maureen, for that very gracious introduction. And thanks again to all of you for attending. I've called this webinar, I sort of thought about calling it, who says Canadian patent law is boring, but ironically ended up titling it something even more boring than that. So I really appreciate you people overcoming the urge to not attend and coming. And I'll try to make things, if not thrilling, then at least useful for anyone who is practicing in Canada, advising practitioners in Canada, or who has interest in Canada and potential patent assets there. Before we get started, just everyone will get a link to the recording and slides. I think there's a link in the chat, and it'll be emailed to all attendees. We do have a Q&A if you want to type questions into the Q&A box, and then we'll try to take those as we go along and have a little Q&A session at the end. And of course, please follow us on LinkedIn or go to the SLW Institute at the Schweigman website to see our upcoming and on-demand webinars. So what I want to address today are recent developments in Canadian patent law and practice, with some strategic advice for anyone who is overseeing patent applications in Canada. Some of these issues are quite recent, and some of them are a few years old, but are really significant and have kind of practice has kind of evolved in the years since. So there are four main issues that I'm going to try to hit today on this webinar. The first is a set of changes that came in October 2022 in Canada. And this was a real overhaul of the Canadian patent examination system. Excess claims fees were introduced for the first time, RCE practice, requests for continued examination. It really changed a lot of the contours of Canadian patent prosecution strategy. And so I'll try to kind of mine the best practices that have developed since then for prosecution strategies, including filing divisional applications and so on. The second issue I want to touch is something that was introduced last year. This is a new patent term adjustment regime in Canada, and we'll go over kind of how that's calculated and again some strategic practice tips for taking the maximal advantage of those patent term adjustments. The third issue is brand new. This is a case of first impression in the Canadian courts. One of the rules changes that was introduced in 2022 was a change in the standard for reinstating abandoned applications, which I know sounds a little dry and procedural, but it used to be quite a big feature of Canadian practice, and the new rules have tamped down on it quite a bit. What we have now is the first judicial decision applying the due care standard that's now in place for reinstating an unintentionally abandoned application. Fortunately, the patentee was successful, and so we'll go over that ruling and what it means for practitioners and for applicants. And then the last thing, if we have time, is I want to just give a little bit of an overview of a recent development, both at the federal and provincial level, The governments in Canada have been really actively trying to encourage innovation by subsidizing IP expenses, especially for small and medium businesses in Canada. These are startups, Canadian startups, but also even foreign companies that have operations in Canada can potentially benefit from some of these programs, and they can be quite generous. So I'll try to give kind of an overview of those and what to look for, what to ask around about, how to structure your prosecution to take advantage of those programs. So before we go into the new stuff, I kind of want to give a quick primer on the old stuff that everybody knows about Canada. And I'm pitching this, of course, to a primarily a US audience of either patent practitioners or patent owners who are engaged in oversight of patent applications in Canada. If you know one thing about Canadian patent practice, it's that there are no terminal disclaimers allowed. And so any continuing application, typically a divisional application in Canada, is not protected against obviousness type double patenting. And so in general, the only divisional applications that are going to get filed in Canada are going to be those protected by the safe harbor from an examiner characterizing the claim set as being a separate invention, like lacking unity of invention, a restriction requirement. So that's the big change. No, there's no continuation practice the way that there is in the US, where you can kind of get another kick at the can at the same general embodiment or invention. A similarity to the US that is shared by almost no other country is that Canada, like the US, has a 12-month grace period after disclosure of an invention, in which a patent application can still be filed. So there isn't an absolute novelty requirement. The contours of that 12-month grace period in Canada are quite similar to the US. The rules for public disclosure are a little different. Offers for sale, these things are not as much of an issue in Canada. They have to constitute an actual disclosure to the public of the subject matter. But in general, the 12-month grace period operates quite a bit like the rule in the US post AIA. Big difference in Canada. You have 4 years from filing in which to request examination. And this informs prosecution strategy quite a bit. It's a very common practice for applicants to file in US and Europe, in Canada, and then prosecute in the US or Europe, get an allowance, make sure that you've got a set of 20 claims that have cleared the bar of whatever prior art is being cited. And only then, you can request examination in Canada, file a PPH request, and usually you can get expedited examination and often secure a patent pretty quickly. So that's a very common strategy, and it's enabled by this ability to delay up to 4 years after filing to request examination. The fourth point here, difference from the US, is in practice, litigation tends to play out differently in terms of what remedies are generally available. And this really informs the value proposition of getting a Canadian patent. And it also can really inform some of your portfolio management strategies and your litigation strategies. So the first thing is that damages in Canada for patent infringement tend to be a little bit more modest than the US. It's all bench trials. There are no juries for patent infringement trials. And so you don't get these bonanza damages awards. Some of them have been significant, but generally the judicial remedies are pretty conservative. So that's sort of, for patentees, that's kind of on the minus side. And of course, Canada in general is a smaller market. It's about 10% the size of the US. And that, of course, affects the amount of damages that are likely to be awarded. But on the plus side, the Canadian courts are pretty liberal with equitable remedies. So you almost always have the option, if you have any operations in Canada at all where you're practicing this invention, you'll almost certainly be able to elect between an award of your damages from lost sales or the profits of the defendant under an unjust enrichment theory. So that can be good, especially for small plaintiffs going after deep-pocketed defendants. Another thing is that Canada isn't sort of living in the post-eBay regime of the US. Permanent injunctions are given out, again, almost as a matter of right. All of the usual equitable caveats apply, unclean hands and so forth, but assuming that in the typical case, these equitable remedies are quite easy to secure in Canadian courts relative to some recent developments in the US. So, if you're litigating a patent in multiple jurisdictions, it sometimes makes sense to leverage some of these equitable remedies in Canada. The permanent injunction in particular can really drive settlement, of course, because just because of the uncertainty. And then at the bottom of my slide, I've got 3 other things that everybody knows to be true about Canada that sadly are no longer true as of 2022. And we'll cover this in a minute. But the first is, it used to be that Canada had no excess claim fees. So you could file applications with 50 claims or 100, or in one case I was involved with had about, by the time I left, maybe 1,800 claims. Probably the reason they instituted this rule. And so that really affects, now it's 20 claims, much like the US, and then you start paying fees after that. So that has resulted in much more compact Canadian prosecution, which is good, because the other big change, it used to be Canada had no RCEs, requests for continued examination. You could just prosecute one office action after another, this sort of dilatory, expansive prosecution. And now, after your 3rd office action, you're going to be issued, you have to file an RCE with a fee. It's not as big as the fee in the US, but it's not nothing. And so that sort of sets a timer under agents when they're prosecuting these patents. The other big change is, it used to be in Canada, you were entitled as of right to reinstate an abandoned patent application anytime within 12 months of the abandonment by paying, I think it was 150 bucks Canadian, a very nominal fee. No questions asked, and you could abandon it intentionally. This led to all kinds of strategies where, you could, rather than filing a national phase entry of a PCT in Canada after 30 months, you could just file it after 42 months. You could go through examination, get an allowance, realize you want to change something about the claims, and you could reopen examination and prosecution by allowing, not paying the issue fee, letting it go abandoned, and then you had 12 months to reinstate and start all over again. None of those strategies are available anymore, and we'll get into the details of that in a minute.
Right, Matt, I just have a very quick question.
Mm-hmm.
So someone has asked in the Q&A, if you don't request examination within the 4-year period, what happens? And I guess the follow-on is, if you've done it accidentally, can you do anything about it?
Let's see. Well, the patent application is going to get published 18 months after filing. But if you don't request examination within 4 years, then the outcome would be an abandonment. So yeah, once it's filed, you're committed. You're either going to request examination, or you're not going to get another chance at that particular patent application. Yeah. Sorry, was that the question was just, what's the outcome of not requesting examination?
Yeah.
Okay.
Yeah. So it goes abandoned, and there's nothing you can do.
Yeah.
So,
Yeah.
Thank you.
Yeah, it is a deadline you want to track. It's easy to lose track of 40 years later. So you go make sure that your Canadian practitioner is using a docketing system where that 4-year deadline is going to be tracked. There's a tendency, especially if there are cash flow limitations, where you kind of get the thing filed, fire and forget, and you think, well, but 4 years from now, I'll have my act together and I'll know what's happening. But a lot can happen in 4 years. So yeah, you want to make sure to stay on top of that deadline. Okay, so the first issue I want to cover here is this set of 2022 changes that introduce excess claim fees and that have really changed the strategic landscape for patent prosecution in Canada in terms of uh, continuation divisional practice, and claim filing strategies in general. So the changes introduced 3 years ago. First of all, every claim over 20 is about, at the current exchange rate, about $70 US. So that adds up. And independent, dependent claims, it doesn't matter. You can have 20 independent claims if you want, but over 20, you're going to be paying fees. And then the other thing that was introduced was this request for continuing examination, which is mandatory after 3 office actions. You're going to be paying a fee, which works out to about, again, at current exchange rates, about $400 US. So not as hefty as the US RCE fee, but not something that you want to just do over and over again if you can avoid it. And there are other implications for RCEs, which we'll get to in a minute. So what's the strategy under the current regime? I mean, in a way, Canada now has, it's a little unfortunate that there's, on the one hand, you can't file continuations like in the US. On the other hand, you're now limited to these 20 claims or you're paying all these extra fees. So one way that practitioners have responded to this new regime is you can still file the application with as many claims as you want. You can file with, let's see, is this the next? Sorry. There was one thing I forgot to hit on the previous slide, which is the way that the fees are assessed. It's done twice. When you request examination, they count up the number of claims and they ding you for everything over 20. And then when the thing finally gets to allowance, they count up the largest number of claims that were pending at any point during prosecution. And if it was higher than the fees you paid when you requested examination, they top you up on top of that. So this has interesting strategic implications. Something that you can do is you can file with your, whatever it's going to be, 150 claims, directed to 6 different inventions or whatever. And then what you want to do is when you request examination, you want to pick your 20 favorites and trim your claims down to just those 20. File a voluntary amendment with your request for examination, limiting yourself to just 20 of the claims. Now, you can wait, because you can wait 4 years to request examination, the common strategy is to see how prosecution goes in other jurisdictions, and then 2, 3, 4 years in, you make a decision about which claims you're going to pursue in Canada, often based on which claim formulations and you can amend the claims, even to in other ways. You don't have to just eliminate claims, but you can amend them to match claims from other that have been allowed in other jurisdictions or whatever you want to do. So you can pick the claims that you want to pursue based on how things have gone in the last 4 years, request your examination, you amend the claim set down to 20. And what is often done is if you think there are distinct inventions in there, and if you think you want to potentially file 1 or more divisionals, you can actually intentionally pick claims that are directed to quite different embodiments. You can have independent claims, directed to what you think might be 3 different inventions, for instance. And then if that provokes a unity of invention objection from the examiner, you're now protected by the safe harbor. So if you have a set of 20 claims, you've requested examination, the Canadian patent examiner comes back and says, you know what, I think claim 1 is a different invention from claim 6, which is a different invention from claim 13. Great. You now have 2 potential divisionals that you can file after finishing prosecution of this first application. So let's say you elect to have claim 1 examined. You can get rid of claim 6 and claim 13. You can pad your claim set back out to 20 based on the subject matter of claim 1. You can go through examination, and then later on you can file a divisional on that claim 6 invention and a divisional on that claim 13 invention. And those are both protected against double patenting objections because they've been deemed by the Patent Office to be directed to different inventions. So sometimes it makes sense to deliberately trigger those restriction requirements, those unity of invention issues, by putting in claims in your set of 20 that you expect to be restricted out. So as I said, because there are no terminal disclaimers, any elective divisional that you can file that's not protected by the safe harbor is going to be vulnerable to double patenting objections, including obviousness type double patenting. So you really are going to be limited to divisional applications that address these unity objections. You can't just file a divisional application with claims similar to the parent, but maybe is slightly reworded. If it's the same invention, you are potentially going to get those claims invalidated, either in examination or even during litigation. So what are the practice tips here? A few things that are not immediately apparent. One tip is if you are filing continuations in part in the US, that you're adding subject matter to an existing application, it's a good idea to sort of file those within 12 months, so they're within the grace period. You want to avoid a situation in which so you want to avoid a situation in which the parent is going to act as prior art on the Canadian application. You also want to make sure during Canadian prosecution that you don't start that if you have a divisional that's protected by a safe harbor, you want to make sure that those claim sets of the parent and the divisional don't start converging with each other and stepping on each other's toes. You want to maintain the distinctiveness of those two inventions, so that you don't, get a further objection from the examiner that, oh, this is subject matter that we've already said was a different invention. You're not allowed to amend your claims to stray into that territory. And then, of course, the strategy of filing initially with, as many claims as you like, because you can always then pare it down to 20 for examination, and you can bring in those claims, those non-examined claims later on during prosecution, either of the initial application or of one of the divisionals that's protected by a safe harbor. And you'll then have full support for those. The claims will already have been written, and you'll make sure that they're fully supported in the specification. So that's, yeah.
Sorry, hey, Matt, sorry.
Yeah,
Just
no,
before you
great.
move on,
Questions. Yeah.
two questions actually. Yeah.
Okay.
So the first question is actually about the calculation of the excess claims fees, and it relates to whether or not multiple dependencies are they counted as additional claims, or say you had claim 1 and claim 2 that are independent claims, and claim 3 is dependent on 1 and 2. Is that a single claim fee, or would it be as in the US?
Multiple dependencies have always been fine, but actually, you know what? I should double check on that one. I don't remember whether that rule changed. It's always been Canadian practice. Even multiple dependent claims dependent on multiple dependent claims were pretty common practice. I believe they're still counted only as a single claim, but I'm sorry, I don't actually remember whether that rule changed in 2022.
Okay, no problem. But well, perhaps we can get back to the questioner afterwards. Yep, no problem. The second question, I'll read this out because it's quite particular. So it says, regarding lack of unity of invention, I remember hearing that the language an examiner uses in addressing non-unity may affect the applicant's ability to profile protected divisionals. Is this true about the language the examiner uses?
Yes, there is to some extent I mean, you do want to be careful, and this is kind of related to the point of trying to make sure that your applications don't converge during prosecution.
Mm.
The language that the examiner uses in raising the unity of invention objection does kind of define the scope of where you can stray in your amendments in prosecution. So there is a danger of you. It's a good idea to revisit the unity objection during prosecution of any divisions. Yeah.
Mm. Okay, thank you for that. And we have one final question on this section. And someone has asked if you could elaborate on why US continuation in parts filed outside the grace period could be prior art.
Oh, yeah. Okay. So it's that if you are filing a Canadian counterpart of the US continuation in part, it's not going to get the same protection as a CIP in the US. So the CIP in the US is protected against its parent, whereas in Canada, it's essentially treated as a new, if you're claiming priority to the continuation in part and you're using the subject matter added in the continuation in part, but the parent has already published more than 12 years previous, you're going to be stopped from, the parent is then going to be counted as outside the grace period. So the US parent is going to be counted as outside the grace period for the Canadian filing. Even if it's filed simultaneously with the US continuation in part.
Okay.
So unlike in the US, you won't get the same protection for the added subject matter in the CIP that you get in the US CIP. Yeah.
Yeah. Yeah. And actually, there are a couple of other questions, but I think we'll take those towards the end, because I know that we have 4 sections to get through. So I suggest we move on, and anything that we will pick up at the end. Thank you very much,
Okay.
Matt.
Yeah. We'll do a Q&A session at the end. I think that it'll probably be some time. Okay, so the next issue is the new PTA rules, patent term adjustment. These came into effect in 2024, last year. This is potentially available for any application that was filed sort of after the end of 2020. And the way it works is essentially the Canadian Patent Office has set a goal for themselves that every application that gets filed should get to, well, if it's going to be issued, it should be issued within 5 years of filing. Or if you delayed more than 2 years to request examination, then within 3 years of requesting examination. So, they want it, if you filed it and requested examination right away, they want to make sure it gets issued within 5 years. If you waited the full 4 years to request examination, they want to make sure it gets issued within 7 years of filing. And every day after that threshold, so the later of 5 years from filing or 3 years from requesting exam, you're going to start accumulating additional patent term added on at the end of your 20 years. And the way the calculation works, so it begins accruing after that later of 5 from filing or 3 from requesting exam. And then days are not, and it'll extend from that start date all the way to the date of issuance. That period is going to be considered an extension on your patent term. However, days during that period in which the ball is in your court, where they're waiting for you to respond to an office action, those days will not count, and any other days where the applicant is the source of the delay. Furthermore, importantly, your PTA term, those days are going to stop tolling when you file your first RCE or when the third office action is issued, and those are essentially at the same time. So this is another reason to be careful about office action after office action after office action. You're not going to keep continuing to accrue patent term adjustment if you have really extended prosecution. So what are some, again, strategic tips for trying to maximize your patent term? If you're in a field where you really want that 21st, 22nd year of patent term, pharmaceuticals and so forth, one thing that you can do is you might want to wait to request examination until you've got all your ducks in a row. You know what your claims, which ones are winners. Maybe you've even got a PPH status available to you because you've got a claim allowed in another jurisdiction like the US or Europe or anywhere else that has a PPH agreement with Canada. You make sure everything is all set to go. Then you request examination. And hopefully then you can zip through prosecution. And to the extent the patent office introduces any delays and you're still prosecuting this thing 3 years after you've requested examination, well, you'll get extra term on your patent. Another tip is that you do want to avoid RCEs. As soon as you have to file an RCE, and that happens after your third office action, you're not getting any more extra patent term. So one way you can avoid this and save yourself potentially one round of back and forth responding to an office action is to sort of preemptively amend your claims to make sure that you've addressed any. If you know there's a piece of prior art that you're going to need to distinguish from, if you know that there's something messy going on in your claims that needs to be cleaned up, you might want to put in a voluntary amendment before the first office action and make sure that these are nice, clean claims that the examiner is likely to allow in, 1 or 2 rounds rather than 6 or 7 rounds of back and forth. So those are just some things to think about if you do want to take advantage of the patent term adjustment, and if you're worried that the delays of the patent office are going to cut years off the life of your patent.
And
Yes.
there's one
Questions,
quick
great.
question.
Yeah.
The question is, how are Canadian patent examiners evaluated or compensated for productivity? Is it similar to the US, or does it work differently?
I'm gonna have to be careful with my answer here. The truth is, it's pretty opaque. I don't have a lot of inside insight here. The lines of accountability of the Canadian Intellectual Property Office are a little murky to me. There is not a lot of officially published material out there talking about internal procedures at CIPO. So it's just very different from the US in that sense. I mean, in the US, the USPTO publishes a lot of stuff. They tell people what they're doing. Everyone kind of knows the game. In Canada, it's all a bit more obscure. Some people know people at the patent office, but I think there's also a huge amount of variation. So I would say certainly there are incentives for Canadian examiners to turn things around, to put out an office action in a certain amount of time and so forth. I don't know how strong those incentives are, and I don't know to what extent they align with the interests of patentees. I've certainly seen my share of Canadian office actions that looked like, when the only objection is claim 19 doesn't have a period on the end, you sometimes wonder whether this was a good use of resources. But there isn't the same interview practice as part of the issue that I think has gotten better in the last few years. Canadian examiners have gotten a little bit better at making themselves available for telephone interviews and so forth. And I think a lot of minor issues now can get resolved that way. But I still think it's lagging a fair bit behind how those things would work in the US.
Great, thank you.
Okay, so let me now deal with a recent development, which is the judicial clarification of the due care standard for reinstating an application that's been deemed abandoned by the Patent Office. So this was a case that was just issued by the Federal Court of Canada this year, I think in January 2025, Matco Tools Corporation and Canada, Ministry of the Attorney General. To give you a sense of the Canadian patent litigation bar, the cozy little world I hail from, This case, the patentee was represented by my good friend and protege at my old firm in Toronto, Abbas Kassam, and he argued it in front of the judge who issued the decision, the illustrious Justice Russell Zinn of the Federal Court of Canada, for whom he clerked as a young man. So very collegial, very cozy. You don't want to burn a lot of bridges in a small world like that. Justice Zinn is great, a giant of the bench, and he's issued really kind of a nice, solid decision here, putting a lot of people's minds to rest about what this due care standard means. So this is the first litigation of the due care standard for reinstatement of abandoned patent applications. What happened was Matco was the patent applicant. They had a third-party service provider handling their maintenance fees, so an annuity service that they retained, and they switched providers. So all of their cases got migrated from one annuity provider to another. In the course of this migration, a data migration error resulted in the application being omitted from the new provider's system. So it wasn't entered properly, or something didn't translate across. And as a result, the maintenance fee was not paid. The deadline was missed. So Matco, when they realized this had happened, they went to the patent office. They tried to have it reinstated, said this was a mistake. This was an accident. Everyone was doing everything they were supposed to. It was a glitch. And the reinstatement request was denied by the patent office. So they took the case to the federal court, and the court reversed the patent office's decision. And what Justice Zinn said was the patent office sort of failed to consider the entire chain of events. And in particular, they didn't place enough emphasis on the proximate cause of the missed payment, which was this data migration error. And what the court lays out in this decision is a two-stage framework for assessing whether due care has been exercised. First of all, you have to assess the steps that were taken by the applicant before the missed deadline, but also the steps that they took after the missed deadline. And if due care was taken at either stage, either before or after the mistake, reinstatement may be warranted. So in this case, the patent office really just looked at what had happened leading up to the mistake, and they said, well, someone should have been double checking something, and then you didn't pay the thing, and once the mistake was made, you hadn't shown due care. And what the court says is, well, look, accidents are going to happen, and one thing is that you should have systems in place to recover gracefully from when an accident happens. And what the court said was that in this case, the Matco had in fact jumped right on top of it. As soon as they realized the deadline has been missed, they paid the fee, they did everything that they were supposed to do to make it right. So what are the strategic takeaways from this decision? First of all, you want to keep as much documentation as you can of all of your good faith efforts. These can make a difference if and when a deadline gets missed. If you can show that you had policies in place, you had checklists, you were, this is how you do things, this is what, this is how you address things, and not just for preventing mistakes, but also recovering from mistakes. But these things can all make a difference in showing that you've exercised due care. So you should probably use compliance checklists when you're, going through a given activity on a patent case. You want to keep documentation of all the payments that you make, all the instructions that you send out to third parties, to a patent firm, to an annuity firm. You want to, to a foreign associate firm. You want to keep copies of the instructions that you receive. And you should have. It's a good idea, of course. I mean, this is not something that we haven't all heard 1,000 times, but of course, it's great to have redundant systems in place. A second pair of eyes, even if you're relying on a third party to pay annuities, it's a good idea to keep track of those deadlines internally, if you can. And all of these things potentially could make a positive difference if you ever find yourself in the position of having to reinstate an abandoned application in Canada, because you could, even if you don't avoid the mistake happening, you can at least show that you did what you could to avoid it happening. Another thing that you want to do is, when the day comes, when a deadline gets missed, you want to just promptly and diligently take all reasonable actions to remedy the situation. And you want to, if possible, do this before the application is officially deemed abandoned by sending out a notice, which can take a little while. So you want to, first of all, correct whatever was missed. You want to respond to whatever wasn't responded to, pay whatever fee wasn't paid. You want to keep documentation of all the steps you took to remedy the situation. And then, if and when it's necessary, you want to submit a detailed reinstatement request, and you want to give them all this evidence of all the due care that you exercised. And if you do those things, hopefully the patent office will be a little bit more generous in its granting of reinstatement requests in light of this new case law. But even if it isn't, then it certainly will help your case should you, God forbid, have to take it to court. So that's reinstatement and due care. And then the last topic that I just wanted to cover is not a legal topic, but is something that I've dealt with a number of times with startup clients in Canada. And it can be relevant not just to Canadian startups, but also to any company that has operations in Canada and who is filing for patents in Canada, who's filing for trademark protection in Canada. These subsidy programs can cover quite a bit of IP related expense. So some of these programs are, these have all been, I mean, most of these programs are less than 5 or 6 years old. And at the federal level, we have a few different programs now in Canada where you can get subsidies for Canadian. So some of these programs are available to called small and medium entities, SMEs, which typically means about fewer than 500 employees. Depending on how your business is structured, you may very well have a Canadian entity that qualifies as an SME, in which case you may very well be eligible for some of these subsidy programs. So programs like IP Assist, where there's a 20,000 sort of disbursement available for paying for IP strategy. So advice from IP practitioners, and trademark filings, patent filings. The Innovation Asset Collective, where again you get kind of credits for filings, subsidies. Elevate IP. Also, this is a program that's run through these various business accelerators, sort of incubators, and there are a number of these entities across Canada where you join and they will, sort of provide some oversight and advice while also subsidizing some of your IP expenses. And these are great programs for, especially for tech startups who might not have the cash flow, not just for filings, but also for spending a lot of time talking to patent practitioners. They can get some guidance from people who have already been through this process in the tech community. So those can be interesting. I'm based in Ontario, and Ontario's got a few of these programs. There are a few in other provinces, but just to give you a sense of an example provincial program, the IP Ontario program, which I've had a couple clients who have gone through this. It's not a complicated application to get this funding, and it's pretty generous. They give you grants of up to 35,000 initially, and over time you can re-up. You can get up to $100,000 in subsidy. They'll cover 80% of your IP related costs. Again, this is for eligibility. You're going to want to be, if large Canadian companies with more than 500 employees are not going to qualify, but a lot of entities do. IP rights intended for commercialization in Canada is the language that gets used, but it's not a high bar to meet. I haven't heard of anyone being denied on that basis, or on the demonstrating potential benefits to Ontario. I mean, if you're a Canadian-based company and you're developing a new technology, these are programs where it's really not difficult to qualify and to get these subsidies, and they can make a big difference in those early days. So one thing that a lot of these programs do require is to have a Canadian IP firm identified as sort of the point of contact for the Canadian IP operations. So you do want to sort of read through some of the fine print on these agreements or these the requirements for these programs, and structure your sort of lines of communication and authority in a clear way, so that you have a Canadian client with a Canadian firm coordinating with foreign firms in the US, in wherever you want to file. Your filings outside of Canada can be eligible for the subsidies. You just want to make sure that things are structured in such a way that you meet the requirements of the program. And then when you fill out the application, you're going to want to think about what's my pitch here of why the Ontario or the federal government should be subsidizing my cool new technology that's gonna put Ottawa on the map or whatever. So that's just a quick overview of some of these programs. Like I said, they can be very helpful for early stage startups, and they can be a nice little cushion for anybody else. 35 grand is you can get a few applications filed, at least at an 80% coverage. Yeah.
Sorry, someone has asked, what's the kind of scale of the federal funding? Are they putting thousands or millions or billions into these programs? Just to give a sense of what the overall, level of funding.
I'm not sure. I haven't talked to anyone about that in a little while. I know that there have been concerns that these programs are going to run out. I've had clients who were benefiting from them quite recently. So I don't think that there's been. I think the programs were initially quite generously funded. I think it was, certainly in the tens of millions, if not hundreds, is what I recall. And I don't know whether that was subject to like a top up at some point. But as far as I know, these programs are all still sort of going concerns. The easiest thing to do would probably be to just talk through the options with a Canadian patent practitioner, and they can help you kind of coordinate your filing strategy and applying to some of these programs. There can be some complications. Sometimes the programs have really restrictive timing requirements, for instance, where you need to tell them exactly what you're going to spend on what 3 months ahead of actually doing it, and then you have a 3-month window in which to spend all the money, and sometimes it just doesn't align with the way these things actually work. But some of the programs are more workable than others, and I think everyone's been kind of working out the kinks in the last couple of years.
It's interesting to know. And are you allowed to use the IP subsidies for PCT and other international filings, or is it Canadian filings only?
Yes, you can use, so the IP Ontario program that I've dealt with directly, I know that for them, you can use it, it's that 80% coverage, and you can use it for PCTs, you can use it for foreign filings, and you can also use some of these programs for trademark filings, and for even advice and transactional work in some of these cases. I would say the major burdens really are kind of, you often need to come up with a detailed budget ahead of time, and then you might have a limited window in which to actually spend the funds. So you sort of need to structure everything and figure out what everything's going to cost ahead of time, and that it means that if you don't consider these programs early on in your IP strategy, you may find yourself precluded from taking advantage of them later on, once you've once you've already filed things, it's often difficult to get subsidized retroactively.
Thank you.
So I'll just sum up kind of some key takeaways from all these 4 points. If you take just a couple things away from the presentation, you want to think about trimming your claims down to 20 before you request examination to avoid those, $70 US per claim over 20, those excess claim fees. You want to think about, divisionals ahead of time. Make sure that you've aligned your divisional strategy with the lack of continuation practice and the risk of double patenting objections. If you have Canadian operations, you should think in the early days about some of these funding programs. And then the last point is, it's a good idea to think about those due care standards when you're instituting your internal workflows, your checklists, all your policies, your written policies, your whatever you have in place, redundant monitoring, all that stuff. Just document as much as you can, show what a Boy Scout you're being about dotting all your I's and crossing all your T's, and that will be a pretty good insurance policy. Should you at some point miss some deadline at the Canadian Patent Office. So that's it. And if I'm here for questions, I think we've got a little bit of time. If
We do.
yeah.
So actually, we've got quite a few questions, in fact.
Great.
One from the start of the presentation. So just going back to the issue around publication. So if you wanted to prevent publication, I presume the publication period is measured from the priority date, rather than if there is a priority.
Yes, I'm sorry. That's right.
Yeah. And what's the deadline if you want to prevent publication in Canada? What would the deadline for doing that be?
I'm not sure. I'm not sure if there's an option to withdraw from publication after filing. That's something else. I can get back to you guys about that. Yeah.
Fantastic. There's a question that actually perhaps the right author actually says maybe Matt can't answer this offline, but I will ask you. It's a little bit detailed, and it's so the person who's asked the question said, I've heard that if the examiner cites subsection 36(2) of the Patent Act, that an applicant can safely file divisionals, but examiners commonly cite a different section, which is section 36.1, which does not expressly permit divisionals, even when there's a lack of unity. And is that correct?
I'm trying to think of whether I've dealt with that directly. That's something else I want to get back to you about. I'm sorry.
Yeah, no, it's a little bit. Okay. So on PTAs, the patent term extension, are these automatically issued, or is it the duty of the owner to request that?
I believe PTA is issued automatically in Canada, but that's another thing I'll want to confirm. Yeah.
Okay. And on claims fees, and actually all fees, does the Canadian Patent Office have small entity fees?
Yes. Yeah, the Canadian Patent Office does have reduced fees for small entities. I haven't looked at the fee schedule in a while. I don't remember whether it's half but it's in the neighborhood of they don't have a so it's for a small entity, and the definition is different from the one used in the US. But there are reduced fees available for small entities.
Fantastic. And there is one final question, which I'll read out. So you mentioned that reinstatement is no longer available as of right for abandoned applications. the question is, but for applications abandoned by non-response to an office action, if the case is currently within the 12-month period, so I think before June 25, is reinstatement still available as of right? I guess the question is, does that kick in immediately?
Yeah, no. So actually, no. I mean, you don't get reinstatement as of right uh, for failure to abandonment for failure to respond to an office action. You're still going to have to, yeah.
Yeah. And there is someone is managing to get a final question in. Lots of questions today, which is a good sign. So I guess this question is there any difference in practice for unity invention practice for Canadian applications, which are the national phase of a PCT? And does this differ from restriction practice for national applications?
Not that I'm aware of. I think that PCT national phase entries get the same treatment as far as unity of objection, unity of invention objections. I don't know whether, depending on the examining office for the PCT, I don't remember whether the Canadian Patent Office adopts the unity objections from the written opinion of the international stage. But I believe that the Canadian Patent Office will issue its own assessment on that.
Fantastic. Well, that's the last question. And thank you so much for taking all those questions, Matt. You've had 15, that's quite something.
Yeah, I mean, these are great questions. Unfortunately, I'm a little rusty on my Canadian patent practice. It's been a few years, but I would be happy to get back to people with answers to some of those specific points.
That's great. Well, thank you so much for that. And well, I guess it just remains for me to say thank you very much to Matt for a really informative presentation. It's been really fantastic. And thank you to everyone who's joined us again at the SLW Institute. And I do hope we see you again next time. So
thank you all. Thank you.
Thank you very much. Thank you.